affidavit of support is pristine, because if it's not, you will not have anything to fall back on. If they determine that they're going to go ahead and apply the totality of circumstances test to determine whether you can qualify for permanent residence or the immigration benefit that you're applying for. All right, so I have a minute to spare. I'm going to go ahead and answer questions. I have given you the T on the public charge rule. Oh, there's one more thing. Let's talk about the changes on the affidavit of support form. In the meantime, go ahead and put your questions in the comments because I'm here to answer your questions. I have a little bit of time, so I'm going to answer as many questions as I can. But let's talk about the form. So the I-485 form, the adjustment of status form, is they've added a number of questions. And the first question that you should know the answer to in order to properly answer this question is if you, the subject, if you are subject to the public charge review. It doesn't ask if you are a public charge. It doesn't ask what public benefits you've received. This is where it's very important to get have representation and have someone understand the implications of the public benefits you've received and whether or not you are subject to the public charge review. For purposes of this public charge rule, they are reviewing whether at any time you are likely to become a public charge due to your dependence, right? You are depending primarily on public benefits based on cash assistance and long-term assistance. And so you should make sure that you answer this question honestly, that you know the implications of your answers, that you understand what you've received and whether or not it applies to you. For instance, if you've received benefits on behalf of your citizen children, then you would not be receiving public benefits. So let's talk about if your child was in long-term assistance, right, or long-term care at the cost of the government because maybe they are disabled. If that is the case, or you're receiving cash assistance because of your disabled child, the government wants to help you to support your disabled child because you have these expenses, you would not be receiving these benefits. You're receiving it on behalf of your citizen child. That's the assumption I'm making, but it depends on how you applied for those public benefits and what the state says. But at the end of the day, you usually, in cases like this, if your child is disabled and your child is getting the cash benefits and the long-term care assistance from the federal government, the state government, local government, it means that you're not the one that's receiving those public benefits. All right. So, and then the rest of the questions, it delves into the details, right? The details, what's your, similar to the affidavit of support, as your household size, what benefits you've received, your assets, your liabilities, your education level, because now they're asking those questions because if you are subject to the public charge review, they're going to apply the totality of circumstances test, and this totality of circumstances test takes these factors into consideration. So that's why they're asking those detailed questions. And you should not just carelessly answer no when you know it's yes, or you have a hunch it's yes. Get legal advice and representation to make sure you go through this, navigate it in the proper way. All right, I'm going to answer questions very quickly. Let's see. I'm gonna try to start from the top. Go ahead. I'm on YouTube. I'm on Instagram. Go ahead, put your questions in the comments and I will answer. So once again, I just want to mention that if you are applying for VAWA or you are in the middle of applying for VAWA, the T status, asylum, this public charge rule, you would not be subjected to it. Hi there, Tigis. It's nice to see you. Good day, CKB. My niece came here on a J1 visa and she's now getting married to a US citizen. However, she was told that due to the fact that she has student loan payments in her country, it will be so if she's subject to the 2-year foreign residency requirement and she was asking her government to write a no objection letter, but now she owes the country money and they're not providing her the no objection letter, then that's a big problem because now if she's subject to the 2-year foreign residency requirement, she has to then go back home or look to another type of waiver to be able to get out of that 2-year foreign residency requirement. So she should definitely get an attorney because it's more on the complex side. How long does Vermont Processing Center usually take to approve an I-130? So you can go to the USCIS and check their processing times. Right now, I'm seeing I-130s being processed a year to taking a year to 12 months. F. Nero, you are welcome. This is very important information. So I'm glad that you appreciate it. So if I stay here, have my baby for permanent resident and use the Medicaid, will this fall under the public charge rule? So they did not mention that pregnant women are exempt. However, they you should get legal advice, right? Because once again, I don't know what the circumstances are surrounding the Medicaid. But what I have just dictated to you is that the public charge rule for purposes of this rule, they're looking at whether you received long-term care or cash assistance from the federal government, local government, state government, the tribal government or territories. And so it's unlikely that you will have a problem, but you should get legal advice just to make sure you're approaching your questions correctly and that you fully understand the implications of that. But based on my review of this public charge rule, they are looking at cash assistance and public benefits, but they did not explicitly state that pregnant women who take, and I don't know what the circumstances are surrounding the application. So this is where it's important to schedule an appointment. How long does it take for a VAWA case to be approved after getting prima facie? So right now, approvals are taking 2 to 2.5 years. What if you do an asylum but later found love and a woman? Will that contradict the asylum? So whether or not you can adjust status through your spouse is still going to depend on the circumstances surrounding them. They have defensive asylum and affirmative asylum. Defensive is usually in court, and that may be more complex, may not be as straightforward as just going and applying for adjustment of status. So it's very important that you get representation to make sure that you're following the right process. In regards to my niece, she's not subjected to the 2-year rule. Okay, so she should get legal advice because I'm not sure what the issue is. What if USCIS was to contact me within 45 days and they did not? I'm married to a citizen. It depends on what they are trying to contact you for. So even if you have affirmative asylum, because for example, you've had some individuals who have come into the United States, maybe you've crossed the border without inspection, maybe you crossed the border and they did let you in, whether or not you can qualify for adjustment of status is going to depend too on the nature of your entry into the country. So just jumping from asylum to the marriage base or having the both of them run at the same time, it may be possible, but it depends whether you meet the requirements for adjustment of status in the United States. It's going to come down to questions like that. All right, that's going to be it for me today. Thanks so much for tuning in, listening to what I had to say. I will be back tomorrow with another great topic. So keep this in mind that there is a new public charge rule, and seeing that it is new, that means that we'll probably be seeing, we'll be now seeing it being implemented, and you want to make sure you don't experiment with this, right? Don't assume anything. Don't assume you are or not, you are not subject to the public charge rule until you can make sure you schedule an appointment and talk about it. Because now it's in the adjustment of status form, and this is all the more reason why the affidavit of support is going to be essential. Because if they are going to do a totality of the circumstances test, you want to make sure that you have that as a positive factor and something to fall back on. All right. So have a great day. I'll see you tomorrow. Bye bye.